Good morning. Can everyone hear me okay?
Yes.
Well,
Yes.
wonderful. I see most of you right now. It's wonderful to have you here. Welcome. My name is Rosa Salori. I'm actually the Associate Dean for International and Comparative Legal Studies, and I actually work a tremendous amount with graduate students in general. And it's wonderful to have this opportunity to spend some time with all of you. I know most of you started this spring. And it's an opportunity to really go over a lot of basic studying techniques, a lot of issues that you may have doubts about, and a lot of tips of how to succeed in law school. As most of you know, our courses are very rigorous and academically challenging, so it is a good idea to prepare and to do a lot of work as you move along during the semester. So a lot of what we're going to be discussing today is how to organize yourself and how to prepare for classes, but also how to prepare for those exams as well. I wanted to tell you that this is a space where you can ask any questions that you have. This is very basic. A lot of you are new to the law school, so it's completely normal that you will have questions. So please feel free to raise your hand. We will be using the raise your hand feature. And I'm also going to ask some questions to motivate that you participate in class, motivate actually that you start getting used to participating in class, because that's very important to succeed in law school. So without further ado, I actually want to talk to you a little bit about the topics that we're going to be covering today. And I'm also going to give you a break because this is about a 2-hour workshop. So I want to make sure you have the opportunity to stretch and digest the information a bit. We are going to we're going to talk about reading cases, and we're going to talk about case briefing. And I know that a lot of this is covered in your legal research and writing course, but this is kind of like a complementary way of practicing case briefing and also to give you an opportunity to ask some questions. We're also going to talk about those famous outlines. I mean, the reality is that that's probably the most important studying technique that's followed in US law schools. A lot of students historically have prepared outlines and they have done very well in law school. This is why we emphasize the need to prepare these. We're also going to talk about something very important, plagiarism, something that we want you or that we want to prevent that you do in many ways, because in many ways it can ruin your legal career. So this is something that we're going to be discussing as well, and something that I want you to take very seriously. I'm also going to give you some tips on research paper writing. Even though a lot of your courses are going to be exam-based, there's going to be a segment of courses that are going to require you to write research papers, including when you do graduate independent legal writing and other kinds of courses that we have. And I know that there's a lot of students that have doubts of how to write research papers. Maybe this is not something that you did a lot in your previous legal education, which is completely normal. But it's something that you may end up doing extensively at UW Law School. So we are going to go over some research paper writing as well. And I'm also going to give you some tips on how to succeed in law school as well. And remember that you can ask any questions that you have, especially in this space. We can always meet afterwards as well. If there's something that you really want to discuss more or want to, that you have lingering questions after we finish this workshop. Okay. So without further ado, I want to talk about case reading. And I think a lot of you have been doing that for the past few weeks. And you've also been practicing on case briefing as well, which is one of the most important studying strategies that you use to prepare for your classes at the law school level, especially in a US law school classroom. And case briefing in many ways, it's about preparing for classes. The reality is that you do have to combine that case briefing with outlining for the exams. So I will be connecting the dots as we move along in this workshop this morning. But a few things about case reading in general. I teach fundamental issues in US law during the fall, and I actually work with a lot of LLM students and with a lot of MSL students. And a lot of students, they always tell me, Dean Celorio, it's so difficult to read cases, especially when they start. And a lot of our classes start with cases like Marbury versus Madison, cases that are very dry and can be very cumbersome to read, especially if English is not your first language. And this is completely normal. We've only been 3 weeks through the semester. So if you're having difficulty reading cases, this is something that's normal. Do not worry. It does get better. But I want to give you some tips of how to speed up that process of adjusting to reading cases. I do think that the first few cases that you read, it is a good idea to do several reads because it will really help you digest that case. It's not that you're going to always have to do this with every case that you read, but at the beginning, I do think it's a good idea to go through specific, basically steps when you are reading cases. I always think that the first read should be trying to figure out what this case is about. Focus on the story, focus on the issue. If you were going to tell a family member what this case is about, what words would you use? How would you describe this case? For me, that's the first read. I don't think it's a good idea, especially when you're training yourself to read cases, to try to capture every element in the first read, because that's only going to overwhelm you, especially if you're having difficulty reading cases. You can have a second read in which you focus more on that holding and that rationale. We will discuss a little bit what a holding means, but a holding is basically the resolution of a case, what the court ruled at the end of the day. And the rationale is the process and the legal reasoning that the court used to get to that holding. The US legal system is a common law system based on case law. A lot of different kinds of legal developments happen in US courts. Our cases are very important. This is why you have and discuss so many cases in your classes. I do think that that second read would be productive to focus on that holding and rationale. And then a third read, maybe you can try to capture that rule. And you will hear a lot of professors talk about those rules. And this is very important because it's the legal principle of the case. It's the principle that you're going to apply later, when you're dealing with another fact pattern, when you're dealing with another client, And a lot of what attorneys do in the US system is they have a client that comes in and they're like, this is my story. Do you think I have a case? And it's going to be very important for you to be aware of those rules and how to apply them to a different case, right? So probably the rule is the most important thing that you're going to get from a case. So it's a good idea to start practicing the absorption of those rules. And it's probably going to take some time to get used to doing this, in the sense that at the end of the day, it's very easy to confuse the holding and the rationale and the rule. But that's something that we can practice today. We're going to do some case briefing today to practice this. And the fourth read, you focus on that case as a whole. By the fourth read, usually that case you're much more comfortable, and you feel that you can capture more of that case. Remember that this is not something that you're going to have to do always when reading cases. At some point, reading cases is going to get easier, I promise. And for those of you that don't speak English as your first language, I completely understand. I don't speak English as my first language either. English is my second language. And when I was navigating the US educational system, I did have my challenges. So I completely understand, but it does get better with practice. So don't get discouraged. We're just at the first few weeks of the semester. By April or even by March, I promise you that you will feel more comfortable, especially if you're doing multiple readings of cases and trying to familiarize yourself with the different concepts that we are giving you. Any other questions before I move forward to case briefing? Because we're actually going to discuss a little bit the Asahi case that I had you read for today, which is a very popular case, and it's a case that we discuss in all of our fundamental issues in US law classes. Any questions so far? And remember, you can ask any questions that you want in this forum. This is the idea is to help you navigate the law school, and the way our classes are taught, and to help you and give you some tools of how to navigate this through the semester. So you can ask any questions you can. Please don't be shy about asking questions. Please put I think one question. I see a comment from the wonderful Gunay. Hi, Gunay, how are you? It's wonderful to have you in the law school. And thank you for that question. And I'm glad, and this is the idea, to encourage you to really promote, that you do as best as possible. Remember that we accepted you because you can do this. And please keep this in mind. And remember that most of you have legal training already. So this is not the first time that you are addressing legal issues. You're just adjusting yourself to a different legal system, right? So a lot of what we're going to be doing today is how to adjust yourself. The faster, the better, right? But don't be intimidated. The fact that it's hard doesn't mean that you cannot do it. Please keep that in mind. We've all gone through it. I went to law school in the United States as well, and I remember how hard it was. It took me a really long time to digest law school, but I survived, and you will survive as well. Okay, Stefania.
I do have kind of a comment and a question, and it's because you say that on the first cases we should make 4 reads, but
if you have the time, a lot of what
yeah, I was gonna come to that. I don't have the time. I mean, I have to prepare 3 cases for each class, and this week it's become easier for me because what you said at the beginning, we get used to reading the cases and identifying the special things that we need to use for the brief. But how do you manage the time to read at least 3 cases before a class, do the briefing that is also time consuming because you need to write with your words? So what other techniques do you recommend?
Well, Stefania, a lot of it depends on your comfort level. We have students here that just by reading the case once or twice, they got it. And they will able to do that case briefing. It really depends on what your comfort level is. But I do have a very high number of students in my classes that don't have that comfort level. So I always tell them, especially those first few cases, it's a good idea to read them several times, even if it takes you longer, because also you're training your mind to think like a US lawyer in many ways. I mean, the reality is that the US legal system is common law based. It works very differently from a lot of legal systems in the world. It's very case-based, which is very different, from civil law jurisdictions. So we have a lot of students each semester that they come with this fabulous education from civil law systems, but suddenly they have to get used to reading cases for the first time in their life, right? So to get used to capturing that issue, capturing that holding, capturing that rationale takes a really, really long time for some of our students, not all. If you're one of those students that by reading the case once or twice, you feel comfortable and you do your case brief, that's great. But not every student is like that. So I always tell students, you know what, you have to kind of gauge your comfort level with studying, right? And what I want to make sure is that you're conducting the exercise of abstracting that issue, that holding, and that rationale, because that's going to be key for you to succeed in your exams. Because a lot of what you're going to be doing in your exams is applying rules. Is applying rules from cases that you have discussed in classes, right? And you're going to have to be very familiar with those rules and those holdings and those rationales. So it's a good idea to kind of train yourself, especially during those first few weeks, of how to properly read cases. And I think case briefings are a very good vehicle to do this. I think case briefings give you the opportunity to actually read the case with that lens. What's the rule? What's the holding? What's the rationale? Did I identify it? And one thing on case briefs also, I've seen a lot of students historically that they pull the case briefs from Lexis or Westlaw. And the thing is, that's the easy way to do it, right? You can just pull the case brief from online, but you're not doing the legal exercise, And I always tell students that this is such an expensive education. US law schools are super expensive. You want to get the most that you can out of your education. So I always tell students, try to train yourself to think this way, even if it's a little bit different, because that's what you're paying for in this education. It's a way of also training yourself to work with another legal system, what will be probably very successful careers, because most of our LLM students really go on to do amazing things. So it depends on your comfort zone. The idea, and another thing, and I just want to thank you, Stefania, for bringing this up, because I do think this is very important. I don't want anybody overwhelmed. I always tell students your wellness is very important. Your mental health is very important. I want you to go through this experience happy and enthusiastic. This is an important educational experience for you. So what I'm giving you is tips. But if there's anything here that overwhelms you or makes you feel that you're not going to be able to manage your workload, then you reduce it. You reduce it. you adjust it. You have to work with your comfort zone, right? So a lot of what I'm going to give you and what a lot of deans and professors are going to give you are tips, but then you adjust. We have some students, for example, that they like case briefs shorter, and they do great doing that. I'm going to give you a very long case brief because I want to make sure you know everything that you can include in a case brief. If you choose to do so, you can have very short case briefs if that's better. Okay. And that's part of also training yourself to be a legal practitioner. I mean, the reality is that when you're in practice, we all have different kinds of management styles when it comes to our workloads, so it's something that you can also train yourself to do while in law school, but thank you, Stefania. Those are great questions, Anybody else have any questions on this? This is a very important point. And remember, these are suggestions. It doesn't mean that if you don't do it, if you don't read it 4 times, you're doing something wrong. No, remember, the idea is that you're prepared for class, that you're training yourself how to think in a common law system, especially in the US common law system, and that this can be productive for your outlining later, for your case briefs, and everything else that you're going to do in the law school. Any other questions? No? Okay, so let's move on to those case briefs. And again, this is a very long case brief, but it doesn't mean you have to do it this long. I'm giving you a long one, slides with a long case brief so that you see all the components that a case brief can have, but it depends on your comfort level. Because a lot of what you're going to be doing case briefs for is preparing for that class participation and being called on in class, which is very important. Many of you are going to be called on in class, and class participation can be a significant component of your class grades. So it is a good idea to be prepared for class. The reality is that most of our classes include a class participation component, and it does count at the end of the day. And we'll talk a little bit about that as we move along, okay? So we are talking about the Asahi case, right? And we're gonna be using the Asahi case, but in the meantime, I wanna give you a review of what those case briefing components are. You have been discussing this in legal research and writing 1, but I wanted to make sure that you had an opportunity to review this again. And remember, your case briefs don't need to have all these components. Title, facts, right? What happened in the case, the story, that's very important. Procedural history, what kind of courts or what was the process of that case, either at the state court level or either at the federal court level, depending on the specific case that you're reviewing. What is the legal issue? And I always tell students the legal issue is the question that the legal question that the court is trying to answer. What's the legal question in this particular case? Remember that holding, it's the resolution. What did the court rule? Was the court in agreement with the plaintiffs or with the defendants, depending on the specific case, okay? So that's very important. And then you have the rationale and reasoning, which are extremely important. How did the court get there? What was the legal analysis that the court actually advanced to get to that holding? And then you have the rule, which is the legal principle of that case. And that can be in many forms. And one of the tricks of reading cases in the US legal system is that more often than not, the rule is not necessarily that clear. That's why this system is very challenging. It's not as if the cases say, this is the rule, or this is the future test to apply, or this is the legal principle. You kind of have to extract it. It's not that clear. That's why it can be very daunting sometimes to read cases, but you get really good at this. The more you read cases, the easier it is to absorb these rules. Can anyone tell me what the facts of the Asahi case are that you were supposed to read for this workshop? And this is good training for class participation. Don't be shy, because it's not a good idea to be shy in your classes. That's one of the things that we train you to do. And remember that it doesn't have to be perfect either, right? Quincy, thank you. I can't hear you. You're muted.
Okay, yeah. Hi, I just turned my camera on. Hey, how's it going? Hello, everybody. Yeah, so the facts of this case was that it was, quite a while back, 1983 or the late 70s, there was a motorcycle accident, and an individual sued the tire manufacturer of the motorcycle, and all the components that made up the tire, the valve, the stem, the tube. And my understanding of some of the facts was that the part of the components that were used into the tube were made or fabricated in another country, that sold some of those parts to a third country, who then imported it into the United States.
Quincy, that was excellent. You captured the gist of the case. Yeah. That's the story, you know, those are your facts. Thank you so much for volunteering. So I wanted to go over some of those facts, right? Again, as Quincy indicated, it's a very tragic case. We have a motorcycle accident in California. We have this person that was involved in the motorcycle accident, Mr. Zucker. His wife was killed and he was injured, and he's claiming that this is a product liability action, that the accident was due to a defective tire, tube, and sealant. And there are a number of manufacturers and companies that are involved in this case that are actually from abroad, that they're not based in the United States. And this is a key component of this case, you know, how do you hold, you know, in many ways jurisdiction over these manufacturers, you know, for activity that happen in the United States, but they're based, they're foreign companies, you know. There's a number of cross complaints here, and this is part of the procedural history. This happens often in product liability actions, but many of them were settled, which happens a lot in the system, settle out of court, except the claim against Asahi. This is why we have a case in this particular matter, okay? Anybody can tell me the procedural history of this case. What happened in this case? Which state courts? You know, how is this case in the Supreme Court? Because this was decided by the US Supreme Court. I see Harriet. Thank you. Hi, Harriet.
Hi. So the procedural history was that Asahi moved to quash Chen Xing's service of summons for indemnification, arguing that the state of California could not exert jurisdiction over it consistent with the Due Process Clause in the Constitution. And the Court of First Instance denied that, and they said that the court did have jurisdiction, so they maintained the summons. Then they appealed to the Court of Appeal, and the Court of Appeal issued a peremptory writ of mandate commanding the Court of First Instance to quash the service of summons. And then they appealed to the Supreme Court, and the Supreme Court reversed and discharged the writ issued. And then it went up to the Supreme Court of the United States, and that was this decision.
Harriet, that was wonderful and very nuanced. That's a wonderful response if a professor asks you in class what the procedural history is of a case. You know, that was very detailed, very well explained, very clear. So thank you for that. And I wanted to give you a summary of the procedural history in this case, you know, something that you can include in your case brief. As Harriet indicated, this was really mostly litigated at the state court level. It first went to the Superior Court, then went to the Court of Appeal of California, and then went to the Supreme Court of California. In the United States, you can actually be granted certiorari in appeals of state Supreme Court decisions. This is something that the US Supreme Court can see and can give certiorari to. So in this particular case, it did grant certiorari. This is something that you're going to cover in fundamental issues in US law. And we will see what the resolution was of the United States Supreme Court, but that's a very important factor here, that it was first in state court and then it went up to the US Supreme Court after that decision of the Supreme Court of California. So I wanted to ask what the issues were, or the questions that the US Supreme Court was exploring before it issued this judgment that you have in front of you, what the issues are, because that's what the issue refers to. I see Quincy. Let's go, Quincy. What are the issues? Thank you.
I think I just didn't raise my hand down, but.
Oh, then you know what? Anybody else want to help? Because Quincy.
I can go though.
You sure?
Yeah, sure. Yeah. So one of the issues was what's the minimum contact? I picked up on that in the case. And I think I also picked up on, does the court have jurisdiction? Can they exercise jurisdiction over a foreign defendant?
Thank you, Quincy. Those are very important issues here. Anything you want to add, Stefania? I see your hand raised.
Yes, continuing with Quincy's intervention, they were trying to figure out whether the standard of minimum context that was established in prior cases to determine the jurisdiction over a foreign company, what was the minimum, what included the minimum context standard? If it's just the awareness of that the product that I manufacture overseas will end up in another state, or if it required another other kind of actions from the overseas company to determine the jurisdiction.
Stefania, that was wonderful. And the key word in this case is minimum contacts. What constitutes minimum contact? And that was actually to justify jurisdiction over a foreign defendant in federal court. I mean, that's what a lot of this case is about. I actually gave you some examples of some of the issues, that are in this particular case in this slide. We're talking about a sole placement of a product in stream of commerce that would reach foreign state enough to have minimum contacts. And I phrase them as questions because I think it's easier to identify a legal issue when you think of them. What are the legal questions that the court is trying to answer, as opposed to just trying to look at that issue in abstract. It's good to think in terms of questions. Another one is whether sole knowledge by a foreign manufacturer that his product will be sold and delivered in a state sufficient to satisfy the minimum contact test. There's another part of the legal issue that the court is trying to answer in this particular case. You also have two more that I think are very important here to look at. One of them is, what is the scope of the minimum context test to determine territorial jurisdiction when defendants are foreign nationals? That's a big aspect of this case, that the defendants are not based in the United States, okay? And lastly, would exercising jurisdiction over Asahi be consistent with the due process clause of the 14th Amendment? And I think one of the most interesting aspects of the Asahi case is that suddenly, how can a product liability action become a constitutional issue? And this is, or a federal question. And this is something that you are going to be discussing more extensively in fundamental issues in US law, but it's a good idea to start trying to catch, what is a constitutional issue and why? Because usually if a case is before the United States Supreme Court, it's because there's some sort of federal question or constitutional issue involved, and an issue that could be groundbreaking in many ways. I mean, the certiorari exercised by the US Supreme Court is very selective. So usually when there is a case like this before the US Supreme Court, is because it did raise an issue that had major national implications in many ways. Okay. Any questions so far? You're doing great on participation, and I hope that you continue doing that in your classes, because everything that I've heard so far is so clear, so clear, and it's evident that you all read the case, and that's wonderful. At the end of the day, that's really what we're asking you to do in classes, okay? What is the holding in this case? That can be harder to identify. And remember, it doesn't have to be perfect. I'm not grading you. I'm not grading you. This is not a class. I don't bite. Ask my former students. I try to be nice to my students. Who wants to take a chance on saying what the holding is? Everybody's shy. Oh, yeah. Who is it?
Booth.
Hello, how are you?
I'm good, thank you. How are you?
Good, thank you for trying. What's the holding in this case?
Sure, well, I don't know if it's the holding, but the conclusion of it is that the court applies sort of a balance of convenience test, and it says that you have to take into consideration the minimum contacts. At the same time, you have to take into consideration if it's convenient for the plaintiff to submit to the jurisdiction of the foreign court. And at the same time, if the foreign if the foreign state where the court is situated has enough interest in the subject matter itself. So based on the facts, it says it's neither convenient nor there is a substantial interest in the matter for us to exercise jurisdiction over this case.
Good. Thank you so much. That was a combination between the holding and the legal rationale. Okay,
Right.
so let's go over both, because you gave a combination. That was a great answer, and it combined a lot of elements. So let's separate them a bit. Okay,
Sure.
So this is holding. The holding in this case, at least my interpretation of the holding in this case, is that exercising jurisdiction over Asahi would be inconsistent with the due process clause of the 14th Amendment. Therefore, the minimum contacts test was not satisfied in this case, and the judgment of the California Supreme Court was reversed by the United States Supreme Court. Okay, that's the resolution of the case, the final decision of the case. But let's go over that rationale, because the rationale has its process, it has its components. Usually, we are talking about multi-layered rationales when it comes to especially the United States Supreme Court, which is the top court in the United States. There's a part of the legal reasoning of the case that's related to that application of the due process clause of the 14th Amendment to this particular matter. Remember that constitutional issue, and it's a good idea for you when you are reviewing U.S. Supreme Court cases to look at what's the constitutional issue here, what's the federal question here. That's a good way to start. And in terms of the due process clause, the court talks about this limit on the power of state courts to exert personal jurisdiction over non-resident defendants. Remember this tension in the federalist system. We have a federalism system of government, which means that there's always tension between the federal government and the state governments, So in many ways, this is a way for the U.S. Supreme Court of placing those limits or regulating in many ways, the kind of matters, that state courts can be looking at, and even the kind of matters that federal courts can be looking at, when it comes to product liability action. So that's a very, very important component of this case. And the U.S. Supreme Court talks about how personal jurisdiction depends on those minimum contacts with forum state. And then this is very important. The U.S. Supreme Court gives and enumerates factors to determine whether those minimum contacts have been in a particular case. The Asahi case gives you factors. Other cases will give you tests. They will talk about strict scrutiny, intermediate scrutiny. They will talk about rational basis. But it's always good to look at cases in terms of what's the test that case or that court is advancing that I should apply to future cases, right? So some factors in this case to determine minimum contacts, the actions by the defendant which create this substantial connection with forum state. This is not supposed to be based on the actions of the consumer, and the action or actions of the defendant that have to be purposefully directed towards the forum state. And there's actually a number of examples that the court gives you. This is wonderful, because if I give you a fact pattern later, which I often do with my students in fundamental issues in US law, of another kind of accident in which there's like all these foreign defendants, these are the factors that you're going to look at to see whether our courts can really have jurisdiction over those defendants, okay? And some of them are in the slide, designing product for the market, advertising, intent to avail themselves of the market, which is actually something, there's a little bit of precision of this test by Jay McIntyre, which is a case also that you look at in fundamental issues in US law. But basically, at the end of the day, the sole placement of a product and stream of commerce is not enough, to have those minimum contacts. And also the defendant's awareness that stream of commerce may sweep product and forum state is also not enough, okay? And then this is very important when you're looking at a case. Remember all this legal reasoning of minimum contacts and the due process clause and the 14th Amendment and all the legal reasoning that I just gave you. How is that applied to this particular case or to the facts? And a lot of what we do in the US legal system is applying that legal reasoning to the facts. And this is something that you're going to be doing in your final exams as well. You're going to have a fact pattern, and you're going to take these legal principles in Asahi and apply them to a new fact pattern and make legal arguments based on that fact pattern. Okay, so in this particular fact pattern in Asahi, The court found that the defendant didn't purposefully establish minimum contacts with California to avail itself of privilege of conducting business activities in the state because Asahi had no office, property, or agents in California. Asahi made no direct sales in California, had no distribution network in California, did not advertise in California. It merely put its product in commerce, but there was no evidence of intent or purpose to serve California market. And what's really interesting about cases like this is think about companies like Apple, for example. Think about the big companies, or think about companies that have these big websites and have national activities, but don't necessarily have offices in specific states. How would you determine that minimum contacts test? How would you determine that intent to avail yourself of the privilege of conducting activities in a specific state? Okay, because that's what you would be doing in a final exam. This is why this is important. Okay. What are the rules in this case? Because this is very important. Anybody remember what the rules are in the Asahi case, or the rule? What is the legal principle in this case? Anybody want to try it? Because that's a very important part of your case brief. Because remember, that's what you're going to apply later to a future fact pattern. Anybody want to try it? We have a shy group here. So I'm just going to give you the rule. But remember, when you're in classes, your professors may not give you the option. So it is a good idea to be prepared to answer questions, even if you're not sure of your answer. And remember that you don't have to be perfect. Keep that in mind. You're just practicing. You're practicing. You're becoming a lawyer. You're in school. So
I'll give it a shot. What was the rule? I'm sorry, Udita.
I just wanted to try, I may be wrong, but has Asahi done something to purposefully avail the jurisdiction to show that it attracted the customers, to show that it was directed its product to that particular market?
That's a legal issue. That's one of the issues in the case. Stefania, you raise your hand. Do you know what the rule is?
Well, I identified one that it says, I'm gonna read it textually so it can be easier.
Okay.
That says that the substantial connection between a defendant and the forum of a state must come with an action of the defendant purposefully directed towards the forum state, and that's kind of answer the issue of what the minimum contact standard is.
That's very close. Very close. Let's go over some of these rules, because this is the most important extraction that you're going to do when you read a case, because that's what you're going to apply later, to future fact patterns. Okay. But good efforts from both of you. Thank you so much. So we have first rule. Remember that this is a constitutional issue, right? So at the end of the day, I do think that there's an important rule here related to the due process clause of the 14th Amendment, which means that personal jurisdiction depends on minimum contacts with forum state, right? And this is particularly important when it comes to non-resident defendants. Actions by defendants need to be purposefully directed towards forum state based on factors listed in the ruling. That's a very important part of the rule. But there's also fair play and substantial justice issues, and this is dicta. This is what we call dicta in cases. But it's part of the court's analysis. It's not necessarily a rule, but it's part of the court's analysis, and it's good to keep it in mind when it comes to future cases. And that means the determination of reasonableness of the exercise of jurisdiction in each case, because remember, this is determined case by case, depends on an evaluation of several factors: the potential burden on the defendant, the interest of the forum state, the plaintiff's interest in obtaining relief, efficient resolution, and state's interest in furthering social policy, okay? So these are all very important components of the analysis. I think your top rule is the one in the top, the one about the due process clause of the 14th Amendment. So always focus on that basic rule, and then you add different kinds of layers to the rule that you think would be important for future cases, or what we call the dicta. The dicta in cases. That's not necessarily the main rule, but it is important to keep in mind, especially when you're applying this rule to future cases. Wonderful work answering questions, and thank you to all of your volunteers. This is not easy to do, but it will get much easier. I always tell students, the more you participate in class, the easier it gets, you know? Afterwards, it becomes second nature, and it does help your final participation grade. Any questions so far before we move on to outlining? Because I'm gonna give you an example of an outline with the Asahi case, okay? Any questions so far? And remember, you can ask any questions. Quincy.
Yeah, so you mentioned this a little bit earlier about using Westlaw or LexisNexis. To what extent would you recommend that we do use that, not necessarily to get to the answers efficiently, but to use it as a supplement to understand the case? Sometimes what I've noticed is that, and I'm very grateful that the professors who have provided some of the cases, they will consolidate it just for shortness. But if we actually look at the entirety of the case and on the internet or somewhere, even though it may be a little bit longer, for some of us who might need the bigger picture, that's more helpful too. So to the extent that these cases are available in the tools that we have, like Westlaw, without using those to find the answer, how can we use that to get a better understanding?
I think that at the end of the day, the most important thing, Quincy, is to make sure that you're not substituting reviewing Lexis case briefs with your own exercise of reviewing a case and extracting a rule and extracting a holding and a legal rationale, right? Because that's part of what we're asking you to do in classes. And this is also going to be very important for you to succeed in your final exams, right? Because this is a system where we don't really memorize. It's not about memorization. It's about applying rules to potential fact patterns in the future. So the most important thing is that that doesn't substitute your own case briefs. And the same with outlines. I always have a number of students every semester that go, Dean Celorio, I found this outline on the internet. Can I use it? I'm like, well, you're not really doing your work then. You know, you're not really doing the work of learning how to think in a common law system or in a US legal system, you know, and it might not help you in the exams because just memorizing is not going to help you how to do this kind of legal reasoning, right? So the important thing is that one thing doesn't substitute the other, you know, and that's what I always recommend to students. Most of the students that do really well are students that did do their outlines, you know, and they did do their case briefs and they really tried to learn how to, you know, how to really read those cases and how to apply them to future fact patterns, you know?
Okay, and maybe just one follow-up question. Would you be able to maybe explain or expand on what makes up the element of a rule? I was able to, you know, it took me a while to pick up on these rules from reading the case. And what I'm afraid is that I may think I've got a rule when it in fact is not what the professor is pointing out as the rule.
No, and Quincy, that's actually a very common concern because it's not easy to pick up rules from cases. So I just wanted to tell you that if you get confused, if at any point you're participating in class and you give a professor a different kind of answer than the professor was expecting, that's completely normal. It's part of the process, you know? Even attorneys, even practicing attorneys discuss what's the actual legal principle in this case, because there are actual cases that are ruled by the US Supreme Court, you know, and federal courts and state courts, that is not easy to decipher the rule or how it will be applied later. And one thing that you'll see in our system too that is really interesting is that sometimes, and this happens very often, future court compositions clarify the rule because they have continued hearing that there's so much doubts about what the rule was that they expand on it or they clarify it. But the most important thing to think about in terms of if you want a basic, for me, the rule is the legal principle of the case. You know, what is the principal legal conclusion of the case? What's the legal benchmark? What's the legal standard of the case? You know, what is the rule that you need to apply to a future case? You know, especially in a system like ours that's based on precedent. What is the rule, you know, that would need to be followed, you know, in a different set of facts? You know, because courts have to follow precedent, you know, if they're going to change precedent, they really have to justify this. They really have to motivate it. And we have a system of a lot of superior courts that can overturn you if you don't follow precedent, right? So at the end of the day, if you're a person outside of the law school, that you're not a lawyer and you needed to know what the rule is or what the law is on a specific matter, what would be the legal principle that that case is giving a person in terms of what to follow in the future, So it's good to think about in terms of what is the law on this matter. It's just that the law is a term that's very comprehensive. So it includes not only cases, it includes other kinds of sources, So, but it's good to think about what is the legal standard that I would have to apply in the future? What's the legal principle? What's the legal benchmark? What is the test? What is the test that I would have to apply in the future? You will read a number of cases, for example, in fundamental issues in US law that have a lot of tests. Like, for example, this one, Asahi. You have a case like Baker v. Carr, for example, that has that famous 5-prong test that's very difficult to understand. There's a lot of especially if you deal with cases of racial discrimination and gender discrimination and the equal protection clause, there's always the scrutinies, either strict or intermediate or rational basis. All of that are rules. All of that are actually standards that you would have to apply later. And I promise that this will get better. It does get better, and it's totally. And I was going to tell you something, Quincy, and I say this to you and the class. A lot of students are very, very, very intimidated about participating in class because they think they're going to make a mistake, and that's not a good way of thinking, because the reality is that you don't have to be perfect. What your professors want to see is that you're trying, that you're training yourself to be a good lawyer. If you didn't need any sort of training, you wouldn't be in law school. So keep that in mind. What professors want to see is effort. They want to see effort. They want to see students that read their cases and they're really trying to capture what cases say and the rules and follow class. So please do not be scared if you say a holding and it just happens to be something else, because that happens all the time. It even happens to us as professors when we're teaching, So please keep that in mind. No need to be perfect. I think what you did today was outstanding, and I'm grateful to all of you who participated today, because it can be pretty intimidating, especially at the beginning. Okay.
Thank you.
Of course. Any other questions before we move on to case brief, to outlining? We're going to talk about those outlines. Very important for your final exams, particularly. Yes.
One small question. When we articulate what the legal issue is and read the case and we come up with an answer, is the answer the rule, or is it, how do we differentiate between the answer that we've come to and the rationale, and how do we distinguish what's the difference between the rationale and the rule?
Well, more often than not, your answer is part of the rule. I think it's safe to say that after you identify the legal issues and the legal questions, your answer is part of that rule. At the end of the day, there's always going to be a murky line between legal reasoning and the rule, right? A good rule of thumb is to think about what would I need to apply from this case to answer future cases. If I were a judge, imagine if you were a judge, right? And suddenly you are brought, there's a specific car accident that happened, and you have all these foreign defendants, right? And Asahi is the main precedent in this case. What would you need from Asahi to apply to the case that you are deciding? What would be the most important components that you would need? You probably need your rules, and you probably need your legal reasoning as well, right? To apply it to the new case that you have before you, right? So I think it's okay to combine in some ways the rule and the legal reasoning. Just make sure that you don't miss anything that you would need to rule on a new case, because that's going to be very important, especially for those final exams. And it takes time, but don't be frustrated if you feel you're confusing them. It does take time, and eventually it will become much more clear to you. And with an outline, I have a sample outline. I think that may help you also navigate this a little bit better. So I'm gonna move on to outlines, because I think some of the questions, the outlining process also kind of helps you in this regard. So you have it more, you have something that's more of a visual in terms of how a rule and legal reasoning and the holding and how all of this can be presented in an outline, okay? So a few things about outlines. When you're thinking about an outline, this is a document that you're preparing to prepare for your final exams. And in many ways, it's the summary of everything that you have learned in class, but it's a very strategic summary that you're going to use that captures those rules and that legal reasoning and the cases that you have discussed in class that you can apply to a future fact pattern. Because a lot of what your classes are going to give you is a new set of facts. And you're going to have to apply everything that you have learned in class from those cases to that new fact pattern. It's not going to be a memorization exercise. It's not going to be as if the professor is going to be like, what was the holding in Asahi? Usually our exams are application exams, which means that you're going to have a fact pattern. And also one thing that you should know is that I understand that most of you are taking fundamental issues in US law. There will be a midterm practice exam so that you kind of understand how exams are structured at the law school level. And there will be a discussion of the answer as well. And also in legal research and writing, we have an exam taking lecture at the end of the semester as well. So a lot of this will become clear as you see examples of exams as well. But it is a good idea to start thinking, to start thinking about alternative sets of facts. Imagine if a case that you have in front of you is about a car accident instead of a motorcycle accident. Imagine if some of the defendants are not, if not all of your defendants are foreign, if you have two defendants that are foreign and some defendants that are based in the US, would Asahi apply in the same way? Would it be the same solution to the case? Or would you have to incorporate other analysis to rule on that case? It's things to think about. Start thinking about application of facts, application of rules to facts, or application of legal reasoning to new facts, because that's going to help you a lot with your final exams. But in terms of outlines, it is a good idea to organize your outline based on the concepts and subconcepts that you have been learning in class, and your syllabus is a very important roadmap for that. For example, when you think of fundamental issues in US law that most of you are taking, some examples of concepts: judicial review, political question doctrine, personal jurisdiction, courts, and others. An example of subconcepts under personal jurisdiction, for example, which is a big concept: subject matter jurisdiction, territorial, and diversity jurisdiction. These are all in many ways discussed in the Asahi case. Okay, remember that we're using the Asahi case. Other things that are very important to include in your outline, and I'm going to give you an example. Remember those rules? It's important to include in your outline case examples of how that rule has been applied in the past. Okay, and also some details about those rules, or what I call the dicta or the rule nuances can be useful too. Your outline should be helpful to your exam. So it's a good idea to test drive it with alternative fact patterns. It's always a good idea to apply and use your outline, test drive it with that midterm practice exam that you will receive in fundamentals to see if it works, because you still have time to edit your outline, and everybody's outline is a different style. Some students have shorter outlines, some students have longer outlines. It really depends on the person. So that's why we don't give you a model. I just give you an example of how it can be structured, but you can definitely do something different than this. So let me just give you some examples. Now remember, this is thinking about Asahi, the Asahi case, and thinking about that subject matter jurisdiction and those minimum contacts and that due process clause of the 14th Amendment, okay? So your concept is personal jurisdiction and basically territoriality, right? And if you think about it, your basic rule, and this is something that you will be discussing in class, you have a large rule and then you have like kind of like different parts of that rule. So your basic rule is that in principle, courts have the power to adjudicate matters concerning persons present within their physical territory when a suit is commenced, but mere physical presence in the form state where the suit is filed is no longer required, right? So that's an initiation of your rule, and we're gonna add some details to that rule, right? And we know that the 14th Amendment and the due process clause of the Constitution are connected to that rule because it protects foreign litigants from litigating in that distant fora, and it assures that states do not reach beyond limits as a co-equal sovereign in the federal system. Remember the federalist system, and that's something that you're going to be covering in fundamentals as well. And remember that minimum context rule. You know, that's a big component of the rule in the Asahi case. Remember that this is connected to the 14th Amendment. And there are different kinds of parts of that rule. And I include some in the slides so that you kind of see what a statement of a rule can look like. In an outline, a person can be present in a state if sufficient minimum contacts are there so that the suit does not offend traditional notions of fair play and substantial justice. Remember that dicta in the case, about why are we considering this a constitutional issue? And there's other cases that you can cite depending on what you're discussing in your particular class. Remember that a defendant must have pursued actions which create substantial connection with forum state. We can call personal availment, but there's different kinds of terminology. You're going to go over different kinds of terminology in your class. And remember that there's this reasonableness standard in determining territorial jurisdiction based on several factors. And you have your case example as well, and you have the Asahi case, because that's the case that you discuss in class under that rule or to apply that rule, okay? The minimum contacts test, but also the fact that the due process clause of the 14th Amendment is involved here. And you include your facts, you include your holding, and you also include the application of the rule, because this is very important, because this is what you're going to do with future fact patterns. Asahi, remember that application to the rule. Asahi had no office, property, agents, direct sales, advertisement, or a distribution network in California, had merely placed the product in the stream of commerce. And that was not considered enough, okay? And then rule nuances. And remember, these are all components of an outline, right? And you can actually structure the outline in any way that it works for you. I'm just giving you one example of something that worked for me when I was in law school. That worked for me in terms of how to present rules, right? But it depends on the person. So it's important for you to determine what you're comfortable with, how you visualize material, and what you think could help you apply these standards in an actual exam, okay? So after you have the basics and that outline, you can actually include rule nuances or dicta or those details, right? So remember that purposefully directed standard to meet minimum contacts, right? And remember the examples that the court gave: designing product for the market, advertising, establishing channels for providing regular advice to customers, marketing product to distributor. And remember that fair play and substantial justice principle that the Asahi court advances. The fact that, there are specific elements that the court did look at, including, the burden on the defendant, the interest of the forum state, plaintiff's interest in obtaining relief, efficient resolution, and state's interest in furthering social policies. This is all part of jurisdiction analysis and whether there can be jurisdiction over non-resident defendants and non-resident companies or companies based abroad, okay? And remember that this is something that you start your outline with what works for you, and then you can polish your outline as you move along, You can start your outline like this, and then suddenly you're like, this is too detailed. I need something a little bit simpler, So it's something that's why it's a good idea to start your outlines already so that you have plenty of time to revise them, to edit them, to apply them to new fact patterns. I always tell students that it's a good idea to watch the news, because there's a lot of different kinds of fact patterns in the news, So the news kind of gives you an opportunity to apply what you're learning in class to facts. I'll give you an example. One big case that you will discuss in fundamental issues in U.S. law is the Youngstown case, which is really about presidential power, whether a U.S. president can actually seize, the bit or order companies when there is a national crisis to stop the activities that they're undertaking and actually focus on a particular objective. And in the case of Youngstown, this was actually about, the president at the time ordering companies, that they needed to start producing steel for weapons related to World War II. The US Supreme Court said, no, you actually need an act of Congress to be able to do that as a president, or you need a constitutional mandate to be able to do it. In that case, we didn't have either. Right now, President Biden has been talking about doing the same with corporations, in the United States, so that they start producing material for vaccines, That is a very, very interesting new fact fact pattern, and when you think of the Youngstown case, does that apply? Would he need an act of Congress and or a constitutional mandate to be able to do that? It gives you the opportunity to apply the case to a new fact pattern. I think it's a very interesting fact pattern because we're dealing with one of the biggest national crises of our time, the COVID-19 pandemic, and I think it's going to be very interesting to see what he decides to do, whether he's going to pursue that act of Congress or whether he's going to find a constitutional mandate to be able to do so. Okay. So I motivate you to start thinking about alternative facts because that really will help you. And it will also help you figure out what you need in an outline to be able to apply and do that legal reasoning in an exam later. Remember that you will have a midterm practice exam in fundamentals that will give you also a sample answer that your professor will discuss with you in class in terms of how to structure exams, and how to apply those rules to facts. I want to give you a break because we've been actually discussing all of this material for an hour, and I know it's online, so it can get tiresome. But before I give you a 5-minute break, I just wanted to see if any of you had questions on either case briefing or outlining before we move on to plagiarism after the break.
Hi, Professor Solario. This is Heather. I'm just wondering, actually, if you will be providing this PowerPoint to us following the class. Okay, great. I'm a very visual person, so I kind of like to have things to build off of, so that's great. Thank you.
Me too. I'm the same way. So the first thing that I would ask if I were receiving this workshop is whether I could have the PowerPoint. So yes, you can have the PowerPoint, and the idea is that you have some sort of example. But remember, it's not a straight jacket. If you see the outline example and you're like, I don't understand any of that. That doesn't work for me. Then you try something different. But just make sure that you capture those rules, that legal reasoning. Make sure that you capture those basic components. But you will definitely have this as a roadmap. And the idea of doing this workshop is that you have at least some basic information of studying techniques, that other students have done historically that has helped them succeed in law school. Law school can be very tricky. I did my law school education in the United States, and I remember how difficult it was to get used to doing case briefing and outlining, and not knowing what the exams were gonna. I didn't know what the exams were. I mean, when I went to law school, we didn't have any of this. We didn't do workshops and things like that. So the idea is that you're more prepared, that you're not so surprised when you suddenly get a fact pattern and you just get a question, advise this person, and you're like, it's good for you to have at least some information of what's coming so that you can prepare better, That's the idea.
Great, thank you so much.
Any other questions? Okay,
Heather
so
covered my question.
Oh, I'm sorry, is there a question?
No, Heather covered my question, so thank you. I'm glad we'll be getting the handouts.
Okay, wonderful. So I will give you 5 minutes and then we will come back with other material that's interesting to cover, okay? But thank you so much for your participation and attention so far. And remember, the idea is that you ask all the questions that you have because this is a good space, this is a safe space to do that, So 5 minutes and then come back. Everyone back? Yes, we're back? Well, it's good to see you again. And I hope you had a bit of a break and that you stretched. And I will do my best to make this second part as interesting as possible. But we do have to talk about something really sad that happens at the law school. It's called plagiarism. And a lot of students, always ask, why do you cover plagiarism so extensively? Why do we cover it in legal research and writing? Why do you cover it in your workshop? Why is it part of the orientation, et cetera? We cover it extensively because every year we have cases of plagiarism. That's why we need to cover it. I'm not saying you're going to do it, and I hope that you don't do it. I hope that you trust yourself and your abilities and your arguments and your writing in a very, very important way to avoid this, but it is important for you to know that we do have cases of plagiarism every year. This is why we cover plagiarism extensively. And plagiarism is representing the words, ideas, or text of another person as yours without proper citation. And one thing that's very important for all of you to know is that you can commit plagiarism without intending to do so, and saying I didn't mean to do it is not a legitimate justification to defend yourself against plagiarism. And we do have an integrity committee that reviews cases of plagiarism. If you commit plagiarism, you can be expelled from the law school. You can be suspended to the law school. This can be reported to the bar. This can really tarnish your reputation as an attorney. It's a very, very serious deal in the United States. And we've even had very high profile figures in the United States that have lost many opportunities and a great deal of prestige because of plagiarism, right? So this is something that I really want you to avoid while you're in law school. And another thing that's important to know about plagiarism before I talk to you a little bit about what we consider plagiarism is that it's very easy for us to notice if you commit a plagiarism. It's very easy to find out. It doesn't take much. Sometimes only a Google search will show me whether a student committed plagiarism or not, right? You don't even need specialized software to see it. So it's important also to keep that in mind, that your professors, these are people that read extensively, that write extensively, and the reality is that for them it's very easy to figure out whether the language that you're using in a specific paper is yours or any sort of writing submission is yours or not, okay? Other things that are very important for you to keep in mind, plagiarism is inconsistent with all of our GW law policies. Again, it's treated very seriously. You can be expelled from the law school because of plagiarism. And I think there's a few rules of thumb that I want you to keep in mind. And I know most of you are not going to commit plagiarism, I just want to make sure that none of you fall into a situation where you committed plagiarism and we have to refer you to this academic integrity committee, okay? Remember that if the language, any sort of language that you're including in a paper that's not yours, that you pulled from a law review article or a book or even a news clip, anything that's not yours, you have to adequately cite it. That means including a footnote and including quotes. If it's not yours, if you didn't come up with it, it does need to include quotes and it does need to include an appropriate footnote, okay? Even if you paraphrase, you're supposed to do that as well. Okay?
Dean, I have a question, if I may.
Of course.
If I borrow an idea from a conversation with a friend or while listening to some attorney in a conference, would I have to cite that as well? And
anything that's not yours, quotes and citation.
How could I possibly cite, let's say, maybe I went to the National Convention of the FedSoc?
I do it all the time.
Oh.
Discussion that was held in specific conference, statement given by this specific expert in this conference.
Got it. Thank you.
It's a wonderful question, though. It's important if it didn't come from you and your own legal thinking, and it came from any other source. Quote, footnote. Okay. Very, very important rule of thumb to follow, okay? Other things that are important to keep in mind when it comes to plagiarism. You can never copy another person's word for word without citation. You need to put the, remember, you need to put the language in quotation marks and the citation. It is not acceptable to just change a few words. For us, even if you have, even if there's no, you know, even if it's only a little bit, it's not a legitimate justification. So please keep that in mind. When you're working, especially on your written submissions for the law school, on your memos, on your research papers, etc. I think your legal research and writing class is particularly important in that sense because you are submitting written submissions. Be very careful, and if you're in doubt, always ask your professor. You can always ask me as well. One of the reasons why we have this workshop is so that you know that I'm a resource and I'm a contact. If you have any sort of questions when it comes to this, it's better to ask. You know, it's better to ask than to fall into this. Other things that are very important, any idea you get from another person, you must cite to that person's work, okay? The same way that you would want somebody to cite your work, you know? We've had a lot of high profile cases, even Facebook. Did you see the social network stealing of ideas, etc.? There's something that we really have a problem with in this law school. If it's not yours, give adequate credit to the source. You would want somebody else to do it for you. Eventually, you might be a scholar. You might be a very successful attorney with amazing and brilliant ideas. You don't want other people using your work without giving you proper credit. So it's a good idea as a professional to get used to doing that when you are at GW Law School. I want you all to review in detail the document citing responsibly. It was part of the documents that were provided in this workshop. It gives you a lot of examples, you know, of what constitutes or doesn't constitute plagiarism. It's really good roadmap, and you're going to discuss it more in detail in your legal research and writing classes. You will even have a plagiarism quiz. You will go over examples of what plagiarism is, etc. It's very important to pay close attention to all of that. Okay, and if you have, and remember, if you have any sort of doubts, there might be doubts, and that's okay. Please ask. I, for example, teach 2 research paper courses. My students, every time they have doubts, they contact me. Dean Celorio, is this plagiarism? And I tell them no or yes, or depending on it is, but I would rather students ask me. I consider that good faith than committing plagiarism themselves, okay? Other things that are very important, and these are tips to avoid plagiarism, okay? Remember to give full credit to all of the borrowed ideas, words, and sources that you include in your paper. This is in the document citing responsibly, so I just want to underscore that. It's a good idea to add citations as you go. A lot of students, what happens is that they don't necessarily go through this process of adding citations as they go. They forget to include citations, and then they fall into the trap of plagiarism. It's a good idea to do it as you go. And it's sometimes this can be very difficult to do because you're rushing and you don't have a lot of time to write the paper, etc. This is something that you want to devote time to. So it's a good idea to add citations, and remember those quotes and that footnote as you go, so that you don't have to go back and forget inadvertently to add a specific quote or footnote, okay? It's a good idea to do a careful check of your papers as well. If you need an extension, ask for an extension, you know? The reality is that sometimes you will need extensions on papers, and it's better to request an extension so that you do a careful review of your paper or written submission, as opposed to just committing plagiarism because of a review mistake, okay? Remember that you will be taught on proper citation form, also in legal research and writing. We're gonna teach you about blue booking, etc. But there's a lot of different ways of giving credit. You know, if you're not necessarily using blue booking, it's a question of including quotes and what the source is, right? Usually, if you follow that rule of thumb, you know, you usually do not, you do not fall into plagiarism, okay? And remember, always give credit. It's a good thing to get used to doing. It's not a good idea to build careers out of stealing other people's ideas. You know, it doesn't make for great attorneys. And remember that you're all so smart and intelligent. You're here because you're very capable. There's no need to commit plagiarism, okay? And if you're overwhelmed with your writing, etc., it's better to talk to your professors. Come to me, go to your professors. There's always ways of navigating this. Plagiarism is never the answer. Even if you're falling behind on a paper, even if you don't have time, even if you're very overwhelmed, it's better to talk to someone like me or your professors rather than falling into this mistake, which can really cost you your career in many ways, So please keep this in mind. I go over it because we always have cases of plagiarism, unfortunately, and I'm hoping that we don't have cases of plagiarism this semester, And remember, also trust yourself. I always tell our students, that I think when students commit plagiarism, it means that they didn't trust their own ideas. It means that they felt that they needed to steal from somebody else to be able to look good. And I actually think that's very sad because it reflects low self-esteem. It reflects a lack of self-confidence on your part. I'm pretty sure your arguments are much better than arguments in other sources. So keep that in mind, your analysis and your written submission should be yours, and you can use other sources to complement, but always give due credit to those sources. Remember those quotes and remember those footnotes, okay? Any questions on this? And I want to talk to you a little bit about research paper writing as well, because I know that a lot of you are going to be in research paper courses or are going to be doing graduate independent legal writing. And I've noticed that we always have a handful of students that maybe this is the first time that they're writing research papers and they end up resorting to plagiarism because they haven't really had that training on writing research papers. So I want to talk to you a little bit about how to write research papers and the role of quoted material in those research papers as well, so that you don't fall into this trap of plagiarism. Harriet, do you have a question?
Yeah, it's about proper source identification during exams. So the way that I take notes is that I'll copy verbatim from the textbook and then put that into my notes and then use those notes for the exam. Would I be expected to indicate that during the exam, or?
Well, that's a great question, Harriet. In law school exams, you can't do that. You can't copy material from an outline and just paste it in the exam. It's not something that's allowed. Usually we're going to give you fact patterns. You're going to apply legal principles and the cases that you have discussed in a specific class and other sources of law to those fact patterns. So you're not supposed to be cutting and pasting material, even from your outlines, okay? In your exams, you don't need to follow Blue Book citation. You don't need to do IRAC, which is something that you're going to be learning how to do in legal research and writing. Usually what students do, though, is mention cases so that they get points for the cases, so that the professor sees, that they did study the cases and where the rules are coming from. But in your exams, you're not supposed to be doing cutting and pasting, okay? So that's something that's important to mentalize yourself, that it's a different system and that it's good to have your outline, right? And you're gonna extract from that outline and use your own language in exams to answer the questions, okay? In your exams, you don't have to do IRAC, which is something that you're gonna learn how to do in legal research and writing, and you don't need to use footnotes either. But remember, you're not supposed to be cutting and pasting material either. This is supposed to be your own legal analysis of the facts.
I kind of more mean in situations where the textbook very specifically and clearly states a rule, and then I want to state that in an exam response. Would I then have to attribute that to the textbook, or I just write that and then incorporate case references as needed?
What you do is that you write your own version of the rule, how you understood the rule, and then you write the case where you got the rule from. That's what you do in an exam.
Okay.
But it's your own language. So it's good to get used to no cutting and pasting. And even some professors like me, for example, in my fundamental exams instructions, I say no cutting and pasting is allowed from previous material. So it has to be your own language. It has to be your own language. And then you put the case where you got it from, or the statute, or the constitutional provision, depending on what you're analyzing. But you're not technically supposed to be doing cutting and pasting.
And accidentally, by some chance, does that have plagiarism consequences in an exam context? It does. Okay.
And I see students that do it. They get really nervous and they just cut paste. And I notice it immediately. It's very easy to notice when students did cut paste. So it's better to get used to not doing it. you know, to train yourself not to do it. You're going to use your own language. You're going to have your outline next to you because your outline is going to help you remember concepts to apply, right? You're going to have it in front of you. It's an open book exam. Most of our exams are open book, which means that you're going to be able to access many materials, but the idea is that you actually apply them. You do your own legal thinking and your own legal application of the rules to the facts, you know? And I know that's very different. A lot of legal systems, you know, they have this incredible education, but it's a different style, right? You can actually do that. You know, you can cut and paste, etc. But that's not something that US law schools allow. So it's good to keep in mind that for exams, for your research papers, for any sort of written submissions, cutting and pasting is usually not allowed. And if you're going to use any sort of sources that are not yours, make sure that you give appropriate credit, meaning put them in quotes and do footnotes. Even when you're paraphrasing, you have to be careful, you know, because a lot of students fall into this when they're paraphrasing. And if it's not yours, cite it, which means that a lot of your papers are going to have a lot of footnotes because there's a lot written already, you know, on most of your topics, you know, but it's very important to kind of train yourself to give credit where credit is due. And in your exams, please keep that in mind because a lot of students, they're thinking, I'm going to have this wonderful outline and I'm going to be able to cut and paste from my outline in my exams, which I understand why they think that way. And then suddenly they get to the exam and the instructions say no cutting and pasting. And the students are like, what? I thought I could do that. No, you know, so it's good to kind of get used to, you're going to have to use your own analysis. And remember that by the time that exams come, you're going to be able to do that. You're going to be able to do that and you're going to do it super well. You're going to do it much better than you think that you're going to be able to do it, you know, because that's what we're training you to do. That's why it's good to do those case briefs and those outlines so that it kind of becomes for you second nature to do that legal analysis and that application to the facts, you know, because that's something that you're going to be doing for exams, you know. But this is a great question, Harriet. I mean, this is exactly the kinds of questions. Please feel free to come forward with these questions because this is exactly what this type of workshop is for, you know, to clarify those aspects, you know. So thank you. Any other questions on that end? On the plagiarism front? Okay, I have a number of questions. This is good. Okay, I had some hands raised and then they low. Oh, no. There they are. Quincy, you had another question?
No, I need to take my hand down. Okay,
so we have Janabi. Janabi, you need to unmute.
Sorry about that.
Okay, there you go. Hi.
Okay. Hi. So the question that I have is, do we also need to add footnotes in our exams if we are okay, we just quote and sort of cite the source, right?
Well, in your exams, you're going to apply your legal sources to your facts and your legal principles. You mention the sources.
Okay.
Just mention the sources and underline them, right? But you don't need to footnote. And you're not going to need to blue book either.
Okay, perfect.
Just make sure you mention the cases because you get more points if you mention the cases.
Got it. Okay.
You can say minimum context, right? And the professor will give you some credit for the fact that you applied the minimum context test. But if you say, oh yeah, Asahi and Jay McIntyre, it looks like it looks like you were really following class, you know? So that's why it's important to mention that. But you don't have to blue book. You're not going to have to do IRAC. Keep that in mind because you're going to be learning a lot about IRAC and legal research and writing, you know, the writing style of the US legal attorneys. And remember, it's not a formal memo. So it's a different kind of exam, but remember, you can't cut or paste. So don't assume that because you have this beautiful outline, you're going to be able to just copy and we notice immediately when you do it. And that does constitute plagiarism. And let me tell you, it's not a good idea to do that in any setting. Like a lot of you are going to become scholars, you know, you're going to teach at the law school level. You're going to be super successful. A lot of people are going to review your writing with toothpicks, you know, they're going to review your footnotes, etc. And plagiarism is so easy to find, so get used to. It's my own thought. This is what I think of the subject matter. And remember, it does not have to be perfect. A lot of our students are like, Oh, no, it does not have to be perfect. That's what law school is about. And I always tell students, we want you to get the best grades possible, but we have a lot of super successful alums that didn't get A's. Keep that in mind too. You do what you can. You do your best effort forward. You take it seriously, and then you take the grade that you were given, right? And then you do something wonderful after that, regardless of what the grade was. What we want you to do is to do as much as you can so that you feel proud of yourself, so that you feel that you did what you can. But A's are overrated. Let me tell you, I know a lot of alums that no A's, and they're doing really amazing things out there. So keep that in mind. This is just a moment in time that we're trying to teach you some basics so that when you go on to have these incredible careers, you have a basic on the US legal system, because that's something that you're going to be able to bring to the table to an employer. That's going to be a big asset for you. And also writing in English, getting used to writing like a lawyer in English, etc. But remember, by no means, it does not have to be perfect. Just try to not commit plagiarism, you know what I mean? And do your case briefing and your outlining. And if you're in doubt, ask. It's better to ask. And one thing that GW has that I think is great is that the deans and the professors are very nice. They tend to be very approachable. So just ask. It's better to ask than to just commit a mistake, or you pulled an all-nighter and you didn't review your paper well. You don't want to fall into that kind of mistake. Yeah. Any other questions on plagiarism? Remember that if you have any sort of questions after the workshop, feel free to reach out to me. Feel free to ask your professors. Most of you are in our legal research and writing program. We have incredible professors in that program. If you have any questions, ask them. They're going to understand if you have questions. It's better to ask questions, okay? Rudy.
Yeah, I just wanted to ask one question relating to case laws. It's very tricky when you do cite a case law or principles or rationale of a case law in a paper or in a research paper or in exams. It's very difficult to get away from the rule. Like even if you write it in your own words, you end up in the language of the case law sometimes. So how to tackle that?
That's a great question. And the reality is that a lot of you are going to be doing that. You're going to be, like basically discussing cases, etc. Cite as much as you can. If in doubt, cite. That's and most you'll see. And if you have questions on this, one good rule of thumb, look at law review articles. You're all going to have access to Lexis and Westlaw and Bloomberg, a lot of the research sources that our library uses. There's going to be a library research lecture on this soon, and actually one tomorrow. You have one tomorrow at 11 in the morning, which you should actually attend with our wonderful librarian, Tracy Emerson. I would look at law review articles as examples. A lot of our law review articles, especially of our professors, that's what they do. They discuss jurisprudence, right? So they kind of give you an idea of how to do your own legal analysis, but also use quoted material, use the cases, use the judgments, how to refer to them without committing plagiarism, So that gives you a good rule of thumb. You can look at my articles. I have a lot of articles published, and a lot of my articles are related to jurisprudence, So it's kind of like that gives you ideas of how to do that interplay between the actual analysis and the quoted material, right? And how to avoid committing plagiarism, But it's a great question. Thank you. Any other questions before we move on to research papers? Because I just had a question on research papers, and I do think that it's good to connect the discussion on plagiarism with research papers, because that's where a lot of plagiarism cases happen. When you're writing, for example, when you're writing your answers to the open memo in legal research and writing, or the closed memo in legal research and writing, or when you're in a course, and the course requires you to basically submit a research paper as the final submission of the course. I teach 2 courses that do have a research paper requirement. And some of you may do also what we call the graduate independent legal writing, that you may do a paper supervised by one of our professors, right? And in all those instances, you know, you have, you know, the opportunity, if you don't really do a good review, to commit plagiarism. But also I think for a lot of our students, not all, I mean, some of you might have had a lot of training when it comes to writing research papers, depending on what your undergraduate or legal studies were focused on. But we do always have a handful of students that this is the first time that they write a research paper in their life, you know? So I do think that it's important to devote a few minutes to writing research papers, because some of you are gonna have to write them. And one thing that I wanted to tell you, first of all, when you're thinking of a research paper, you're supposed to be advancing your own ideas and argumentation and analysis and your own outlook of a specific issue in a research paper. So it's very important that you train yourself to think about ideas, premises, propositions, questions that you want to answer in that research paper. And you're going to be doing this analytically, applying different kinds of sources of law, right? And usually a good research paper has a combination of your own thinking, of your own ideas, but also quoted material. You know, you can review you can review past literature on a specific topic. You can review what other authors have said about a specific topic, and you can use that to complement your own legal analysis. But it's very important that you always give due credit to those authors, and that you include that material in quotes and also in footnotes, okay? And one important rule of thumb when you're thinking of a research paper is that quoted material should not be most of your paper. Every year, we see 1 or 2 students that submitted a research paper that is all quotes. And that's not a research paper. A research paper is supposed to include your own legal analysis, your own ideas on a specific topic or subject matter, and the quoted material is supposed to complement your ideas. It's not supposed to be just the only component of a research paper. And in terms of the structure, if you are in a research paper course, or if you are in a graduate independent legal writing, I always tell students, always think in terms of, I need an introduction, I need sections, and I need conclusions. And one thing that I didn't include in the slide is that there should be a title as well. When you're thinking of a research paper, there should be a title as well. And introductions are very important when you're writing research papers, because that's where you basically explain what you're going to do in the research paper. You explain the importance of your topic and why you chose it. You present your premise or your question or your idea or your argument, what you're going to be analyzing in that paper. You discuss the sources of law and how you will apply them throughout the paper. And you also explain the structure of your paper. When you're writing any sort of research paper, it's always a good idea to say, in section 1, I am going to be analyzing this issue. In section 2, it's always useful for the reader to understand what you're about to do in your paper. It's important then to have your sections, which is really where the gist of your analysis is. And this is where you're going to advance your own legal analysis and arguments. You can include subtitles. I think subtitles, I'm a big fan of subtitles, and I think that they really, really help the reader follow the analysis. But remember, your legal analysis should be there. It shouldn't be just quoted material. It's very easy to fall into plagiarism when you only include quoted material. There should be your own legal analysis, and then you can quote other material that complements your legal analysis. Train yourself to thinking, this is my paper, so my voice has to be here, my own sentences and writing has to be here, but I can use sources and quoted material as a complement, okay? And then you have your conclusions, and your conclusions usually is where you present insightful observations and the future implications of this topic, and also recommendations. I always tell students, when you think of research paper writing or any sort of writing, it's very important to think of clarity. Clarity is the main word here, And when you're thinking of a specific paper topic, think about explaining it to a friend or family member. If you can explain it in 2 or 3 sentences, you have a good paper topic. If you have difficulty explaining it, then there's clarity issues. So that's something that you want to think about, how to present your ideas clearly. And I always tell students that this really, really is vital for a good grade in a paper, the clarity of your ideas, premise, proposition, or arguments as well, okay? So keep these in mind in terms of basics, you know, when you're writing any sort of research papers for your classes. If you have any sort of doubts, remember that you have wonderful legal research and writing professors. You know, they're always willing to answer your questions on research paper writing, but keep in mind these components and these basics, you know, when you're writing a research, any sort of research paper. And I always tell students introductions are really valuable. You know, introductions really give the reader a roadmap of what you're trying to do. If you need examples, look at law review articles. Law review articles are a little bit larger than most of the papers that you're going to have to write. I mean, most of you, your papers will be between 20 to 30 pages in law school. Law review articles tend to be longer. You know, they tend to be 60 pages or more, but they give you a good idea of how to frame an introduction, how to explain a topic, what a clear topic can be, how sections can be structured, the subtitles within sections, and also conclusions, you know? So it is a good idea to look at law review articles as examples as well, examples of good writing so that you can structure your writing as such as well. Any sort of questions on research papers? Quincy.
So can you, do we have any access to additional resources at GW to you know, to help practice or get better at writing, maybe access to writing centers or?
We do have a writing center at the law school, and you can actually schedule appointments online. They're still functioning online, and it is a wonderful writing center. All of the information on the writing center is in our website, but also your legal research and writing syllabus has information on the writing center. So you can definitely schedule appointments with them. Usually the writing center gives you tips on style, on writing in general. They're not there to review your grammar or any other components of your paper. But if you have, for example, questions on format or style or things like that, it is a great source. It can definitely be a great source of help for you. I think if you want to practice your writing, it's also a good idea to pick one of our research paper courses, you know? We have a lot of research paper courses, you know, and I can name a few, you know. We have international negotiations, law of war, nation building and rule of law, regional protection of human rights, international human rights of women. I mean, there's a lot of courses in the law school that are research paper based, and some of our seminars as well. And they give you the opportunity to kind of practice your writing skills. And you can always do a graduate independent legal writing that you can ask one of your professors to supervise your writing for 1 credit or 2 credit, depending on, you know, the specific, but you work on a paper with your professor during the semester, you know, and that can also be a way for you to practice your writing. I do think that when you're and I always tell students, you know, when you're out there and you're practicing as an attorney, one of the most important skills that you bring to the table is your writing, if not the most important one. But I think it's one of the most important ones, and it does differentiate you from other attorneys. You know, good writers get a lot of opportunities, you know, and at the end of the day, it does, especially many of you that, you know, you may be working in other countries, you know, knowing how to write well legally in English is a major asset as well, you know. So it's important for you as attorneys, but it's also important for attorneys, you know, that are doing their LLM degrees in the United States and may be practicing in other countries or at a more global level. I do encourage you to really try to do everything you can to polish your writing during law school, because it's a very important skill. I mean, it's something that's really going to help you later in your career, you know, and I do think the Writing Center gives you good tips. I think our legal research and writing course is fantastic. You know, I think that our professors are amazing. We're very, very, very lucky to have the professors that we have. And remember that we have legal research and writing 1, and we also have legal research and writing 2, you know, during and we offer it both in the fall and spring semesters. So if you, after you do your legal research and writing 1, if you want more writing practice, you can join also legal research and writing 2, you know, although that course is more tailored towards the bar, the reality is that we do cover a lot of basics in writing as well, you know, so that is a good source as well. Any other questions? Remember, this is a space where you can ask any questions you have. Okay, so to conclude our workshop, because I've had you here for almost 2 hours, so I know most of you must be really tired, and I know this is a lot of information, but thank you for your attention. I hope this is useful to you, and please feel free to forward any sort of questions that you have, or I'm usually, it's sad that we're actually virtual, because I usually I have a good office at the law school, and I love receiving students to discuss their careers and their academic life, etc. So, but for now we can do this online. I do have office hours, and I do meet with students. So if you ever have any sort of questions, feel free to send me an email. I'm including my email in the last slide of this PowerPoint. But I wanted to conclude with, I always call these the tips of what not to do in law school and tips of what to do in law school, okay, to succeed. And this is from the experience of many, many, many students that we have seen over the years, and the things that they have done to succeed, and the things that some students have done that haven't helped them in law school, okay? So a few things. It's always a good idea to be very respectful to all of your professors, administrators, staff, and classmates, everyone at the law school. The reality is that there may be moments in which your professors do things that you don't agree with, but these are your graders, remember? The reality is that professors do have a lot of discretion in the law school of how to assign grades. So it is a good idea to always be respectful, even when you're not in agreement. This happens, but it's always good to be respectful. And we mentioned this because we always have some students that are not. So that's why I mention it. I always tell our law students that it's very, very healthy to get used to using email and social media appropriately when you're in law school. Some of you are lawyers already, and some of you are aspiring lawyers, or some of you are studying law because you already have successful careers, and a law degree, an MSL, for example, will be a very, very important credential for you to have. And the reality is that remember to not put anything in writing that you may regret 5 years from now or 10 years from now. I always tell students that if you have any sort of issue to discuss with your professors, more often than not, it's better to schedule office hours to discuss it in person. Just be very careful what you put in social media and email, especially any sort of statements that can be disrespectful or considered racist or considered forms of intolerance. I mean, we do have a very strict policy against that at the law school. So just try to train yourself to use email and social media appropriately. I know we're in a generation where everything is in social media, but I do think it's very important, especially as aspiring lawyers, to think about and not to include anything that you may regret 5 years from now, 10 years from now, okay? Remember to not plagiarize. If you take one piece of advice from today, do not plagiarize. Do not do this. It's not worth it. And you're smart enough. You don't need to do plagiarism, okay? Other things that are very important. Do not wait until the last minute to prepare for your exams. Take studying seriously. This is a very, very, very hard school. We're very academically rigorous. This is a top 25 school in the United States from 360. It's hard. It's going to be hard. Your exams are going to be hard. Your professors are trying to challenge you. It's not a good idea to leave studying to the last minute. And a lot of students do. And the reality is that most of the students don't do very well when they do that. So it's a good idea to do it, do a little bit each week to kind of stay consistent. It's not worth leaving it to the last minute. When it comes to research paper classes and writing classes, try to train yourself to do timely submissions. We always have students that ask for 2 and 3 extensions. And I always tell students, we're preparing you to be practitioners as well. And when you're out there and when you're practicing, you can't always postpone the paper. You can't always postpone the submission. Sometimes it's due and you have to make the effort and do it. So try to train yourself to request the least extensions possible. It's a really good skill to have. Sometimes you will need extensions, and that's okay too. If you're too overwhelmed, remember that wellness is very, very, very important. I mean, this is an important point in the slide. Your mental health, your wellness is very important. If you're ever struggling, if you ever feel that you really, really need those extensions, request them. It's better to request them. It's just to try to get used to not requesting so many of them. And if at any point you're too stressed out at the law school, please come to me. please come to the administrators, please come to your professors. The reality is that we're here to help you, and there's always a solution, okay? So please never bottle yourself inside any sort of major stress that you're going through. I care about you. A lot of administrators care about you, and your professors care a lot about you, okay? So keep this in mind. Do not miss classes consistently. I always tell students this. We always have 2 or 3 students that they go to the first class and then they never show up anymore. And I'm like, this is such an expensive education. Why would you want to miss so many classes? Go to your classes. That's part of the law school experience. We have great professors, some of the best in the United States. You don't want to miss classes. Go to class, participate, be part of the experience. And this does affect your final grades as well, so it's a good idea to go to class. And lastly, some tips to do well in law school. Remember, prepare well for class. Do that case reading, do that briefing, do your outlining, okay? And one key to success in law school is working in class and outside of class. Remember, your professors are only going to give you some of the learning, but you're going to do a lot of learning outside of class as well. You're going to be the ones that are doing the case briefing and the outlines and reading those cases, etc. So it is very important to train yourself to do that work outside of class. Remember those outlines. I always tell students, students look at me when I talk about outlines, they're like, but I can just pull that from the internet. And I'm like, well, that's not as effective. I think it's a good idea for you to try to do yours. And remember, they don't have to follow the model that I'm giving you today. You can do a different outline. Just make sure that it includes the rules and the holding and the rationale, that it includes the material, that you discuss in class, and that material that you're going to have to apply later. And remember to go to class. Go to class. That's important, And also, one tip to do well, participation in class does count. The reality is that your professors at the end of the semester, they have to follow curves when it comes to grading. Every class in the law school is curved. That means that they have to decide, which students are going to get A's, which students are going to get B's, which students are going to get C's. And part of the grade is blind graded because we have a lot of exams, right? But part of the grade is also participation. A lot of professors can bump your final grade, from a B+ to an A-, for example, with good class participation. So I always tell students, try to raise your hand at least once in class every week. Ask a question or say a comment. And remember, it does not have to be perfect, And the worst that can happen is that your professor does not react positively. You take it, right? You learn from it, and then you go and do something fun after class, It's not a big deal. I always tell students, a professor yelled at me in class. Look, it's not what we want, right? It's not what we want, and most of our professors don't do that. But the worst that can happen is that your professor doesn't agree with you. That's okay. You move on. And then in the next class, you speak again, okay? And that professor will remember you. The professor will be like, look, that student is trying to participate. They're trying to be engaged. They're trying to be in the class, and professors really, really value that, okay? So participate in class. I always tell students it's good to schedule office hours with your professors. Try to build a relationship with your professors. Your professors want to get to know you, So it's good to schedule office hours. Do not be intimidated by that. It's good to talk to your professors. And remember, you are going to act professionally, right? You're all going to be great, and you're going to respect professors and administrators and staff and classmates. And that's going to help you build really positive relationships while you are at the law school. Please do not underestimate the importance of self-care. We are still in the middle of the COVID-19 pandemic. We are online. The reality is that we are living through very, very difficult times. And the reality is that there's a lot of stress involved in the current moment in time. And I understand you. You have my solidarity. The law school is worried about that. We want to make sure that you are all okay and you're healthy and you're navigating this experience, in the most positive way possible. So if you ever need resources, if you ever feel too overwhelmed, if you feel that it's too much, which could happen because there's a lot going on in the world right now, please let us know. because we'll be very, very happy to help you and to help you navigate this moment in time. And I always tell students, you know, even though we're online, try to go to events. You know, all of the programs organize events, especially by Zoom. There's a lot of use by Zoom right now to organize events and speakers, etc. And there's also a lot of work related to student associations. Join student associations. You know, I do think it's a good idea to be engaged with the law school. You are graduate students, you know, you're part of our community at the law school. So it's a good idea to be engaged at the law school as well, you know, and it's a way also to feel like you have discussion spaces and also to make friends and other kinds of aspects that are important in your law school experience. But lastly, have faith in yourselves. You know, I think you're very smart and you're very intelligent and you're here for a reason, and you can do well. You know, you're fully capable of doing well in law school. And some of you might be like, why is she saying that? I know I can, but some of you don't think that. So I'm just telling you because we work a lot with students, and I just want to make sure that you know that I have my full confidence in you, that you're going to do great, and we're all going to support you in that process as well. And if you ever have any sort of questions or anything, feel free to reach out. I have my contact information at the end, and I wish you the best of luck this semester. You know, I do hope that I have more opportunities to interact with you. I'm very fortunate at the law school that I'm able to interact pretty frequently with LLM and MSL students. So feel free to reach out if you have any sort of questions, etc. And I wish you the best. You know, I hope the semester is going well, and I hope that this was useful to you. And remember that if you have any sort of questions, feel free to reach out. I don't know if you have any sort of final questions before we close this workshop, because we've discussed so much in 2 hours. And I just want to make sure that you rest, and you probably have other classes today. Any other questions before we close? No questions? I think everybody's tired, and I understand why. It was a lot of information. So yeah, well, it's wonderful to meet you. It's a pleasure to be connected to you. Feel free to ask me any questions if you have any questions, and best of luck with everything this semester. Okay, I hope we have other opportunities. I hope that we have other opportunities to interact. And I'm looking here at the chat. Oh, these are lovely comments in the chat. Thank you so much. This is so nice. And you're going to do great. You'll see. In April, you're all going to be reading cases, and you're going to be like, wow, I remember how hard it was in January. And you're going to feel much more comfortable by April, you know, and by exam time. And we're going to help you in that process as well. Okay. Well, without further ado, I think I have to close this workshop. Have a great day, okay? And remember self-care. I always tell students, aside from all the studying and all the courses you're taking, find something fun that you do per week. That's very, very important. That's gonna help you not only in law school, but when you practice as an attorney later, okay? So self-care is important, wellness is important. So think about something fun to do, you know, okay?
Thank you.
Thank you very much. Have a great day.
It's nice to meet you all.
Thank you.